Good morning, everybody. You all know me. I'm Olga Statz, and today I'm joined by two special guests. We have our soon-to-be commissioner, Asim Rahman, and our acting commissioner, John Castelli. I'm going to turn it over to John, and he can say a few words about our new commissioner.
Hi, can everyone hear me? Great. I didn't mute. I'm not speaking muted. Good. Thank you, Olga. This is really a special day. 54 years. The Environmental Control Board has been going for 54 years, and there are special days, and this is one of them. And I am honored and privileged to introduce our new commissioner, Asim Rahman. I am excited. We are all excited about Commissioner Rahman's joining us and looking forward to his leadership. I know it'll be outstanding. I know, and I look forward to, all of us look forward to working, serving our city, working under the commissioner's leadership. And I'm not going to get into all of the wonderful things I could say about the commissioner, because the board, some of you would quit with the amount of time it would take for me to go through it. So, but I'm not going to do that. And I could, if anybody wants to reach out to me, we can schedule a three-hour seminar to talk about all the achievements and accomplishments in his career and lifetime. So, without further ado, I want to introduce Commissioner Rahman. Commissioner Rahman.
Thank you, everyone. John, thank you. That's very generous of you. I do appreciate it. Good morning, everyone. Asim Rahman, the incoming commissioner. And thank you for allowing me to spend time on your agenda to say good morning and to welcome you and to thank you for the important work that the board does. This is a vital organ in city government, and it's an important part of the work we do to make sure that we have fairness in our processes and that we enhance the public's trust in the important work that city government does. So I am still in learning mode on a lot of these things, and am happy that I can be here and listen in before I start officially. I'll be joining Oath next week. But again, just wanted to be here to listen, to learn, to see you all in action, and to thank you for the work that you do. I will turn it back to today's chair, but thank you again. It's a pleasure to meet you all.
Thank you so much, Commissioner. Again, good morning, everybody. I'm going to ask Joy to do the roll call, please.
Good morning. I am going to start with Olga Statz as the designee for the acting commissioner, John Castelli. Shamanda Graham.
I'm here.
Joseph Gregory.
Present.
Elizabeth Nauer.
Present.
Alan Liguri.
Present.
Jorge Martinez.
I'm here.
Russell Perkunas.
Here.
Matthew Schnei.
Present.
Thomas Shepner.
Sorry, present.
Matthew Smith.
Present.
Douglas Swan. And Jared Whittington.
Present.
Okay, we have a quorum with 11 out of our members.
Thank you so much, Joy. First thing I'd like to do is to ask for a motion to adopt the minutes, please. Thank you. So I see a motion from Matt, second by Elizabeth. Does anyone have any corrections or additions for the minutes? Can you take a vote on the minutes, please, Joy?
Sure. At this time, I'm going to ask if anyone has any objections to the adoption or the approval of the minutes from the February 10th, 2022 ECB board meeting. Any abstentions? Okay. The minutes have been approved.
Thank you very much. So the first substantive item on the agenda is the adoption of our amendments to our appeals and representation rules. The documents were distributed earlier, and you've had all the chance to review them, and you'll see that these amendments are nothing radically different from what we've had before. They were all amendments to streamline our processes and to adopt certain practices and to codify certain practices that we found have worked very well for us during this period of time and worked very well with us as we've taken on the remote work, the remote hearing section of what we're doing. So I present these to you, and I'm interested in knowing if you guys have any questions or if there's any clarification I can bring. I don't hear any questions. So,
Olga? I'm sorry.
yes.
I did have a question, Olga. This
Yeah.
is Elizabeth Nauer, appointed member. There's a few places in the proposed rule that reference, I guess, forms or means that will be identified by oath for certain submissions to be made. And I'm just wondering logistically, how will those processes be communicated to the community that's likely to be affected by them?
A lot of the forms, or most of the forms, are going to be on our website. A lot of this also is done by email, and the contact information and the forms are on the website. And when people call or contact the office, also provisions are made for them as well.
Okay, thank you.
You're welcome.
Hi, Olga. Shamanda Graham, Department of Buildings. In looking through the rules, I see that they are very much similar to what we have, and some of it is stuff that we already have. The one thing that stands out to me as an enforcement agency is it looks like you guys have some control over whether the high volume reps would be able to add cases on once they've provided you guys the list. So I just like confirmation that once you guys have the list of cases that they intend to do, they are no longer going to be able to last minute add cases. Of course, giving you guys discretion to make a decision.
So you said it exactly right. So ultimately, we would have that discretion, but in extreme circumstances. The way we drafted these rules is to set down very clearly the number limitation and to make sure that there are no last minute changes, because it creates havoc at clerks and at hearings. The only last minute action that an attorney or a high volume rep can take is to withdraw cases. That's the only thing that they can do completely in their discretion. But if they want to add cases or if they want to shift things around, they would have to seek the special permission from oath leadership. Otherwise, things are not going to go forward.
So I'll just say that I truly appreciate that, because that it creates havoc for you guys, also for the agencies. But it is very convenient for the high volume rep, especially if they're doing it at the last minute towards the end of the day. So I just really want to thank you guys, because the rules as crafted, provided that they're imposed, they are definitely going to make things much smoother and much better. Thank you all.
You're welcome. Thank you. Hi.
Hi. One of the parts of the rules say the representation needed an original signed authorization, and I'm concerned that practically the way the world works, it's not going to be like an original inked signature. It may be by PDF or otherwise, happening electronically. So I want to kind of understand the rationale for that part of it.
The rationale for that part of it is unfortunately the high number of situations we have where representatives who are not authorized to represent particular respondents actually go in and make representations on the record and actually adjudicate a case. And then the respondent finds out about it afterward. And what our obligation is to redo that hearing. And it's very odd. This is something that surprised me when I first started working here as well. because I was wondering, why would you do that? You're not guaranteed to be paid, but obviously some money's being made somewhere because it happens with such frequency.
Well, maybe I can ask another way. I'm totally fine with getting the authorization. I think it's reasonable. It just specifically says you need an original copy of the signed authorization as opposed to a PDF copy, which I think is just not necessarily practical in today's age, in especially taking in light that we're doing this all electronically.
Well, I think that electronic signatures, when they're full electronic signatures, are something that the clerk's office and the hearings department, the hearings division would perhaps consider. However, if it's just a scanned copy, that would be problematic. I mean, I'm just speaking right now, just in general. I think that would be, because that's one of the problems that we had. Scanned copies, just photocopies, they often were doctored, etc. So it would have to be, it would have to be some actual method of authenticated signature on the PDF. I think that our clerk's office and hearings would probably accept something like that, but a simple scan is, given our experience with this, it wouldn't be sufficient.
I'm just concerned that practically most people they don't get originals. Like I signed literally unrelated to this, but I could do a $200 million sale of a building in my day-to-day life, and there's no original of the signature. Like if the lawyer's going to commit fraud by doctoring a signature, I mean, that's fraud, right?
However, even in that, I'm sorry to interrupt you,
Sure.
Matthew. However, even in that, those signatures are not just ink signatures scanned through. Those are, when I sign things, when I have to sign documents on behalf of Oath, I sign them electronically as well, but that's an entire process. I have a password, all this other stuff happens. So I'm surmising that both clerks and hearings, when they're confronted with documents of that caliber, they will be considered as original signatures. What we just want to make sure is that we don't have just photocopies or scans.
Right. Well,
I'm not really understanding the difference in terms of the capacity for fraud. I mean, if the issue is, because I think Matt's raising a really good point in terms of the way people operate on a practical level, particularly for something like an oath appearance, where it's not, like, in most cases, not a huge like financial risk. So people might, retain a representative kind of late in the game to appear for them. I'm just, and so maybe it's sort of done informally by PDF over email to get the authorization, but what is the fundamental larger capacity for fraud between a scanned signature that still can be compared or shown to the respondent to determine if it's their, compared to their actual signature, versus an original signature, which the representative has, but which they are providing to Oath, generally speaking, through electronic means anyway, because they're not, in general, appearing in person. So I'm just wondering, like, what is the additional security that the ink signature provides in comparison to scanned PDF that the respondent sends to the representative?
Well, as you saw from the rules, the rep is supposed to maintain that signed document with their own records and only present it to us when we require it. So in that case, when we have a doubt about whether the representative was actually authorized, that ink signature is the only thing that's going to help us. We've had so many instances where documents have been doctored. Signatures from one document are lifted and put onto another document and then scanned through. And then the respondent says, yeah, this is my signature, but I never signed this paper. And then it's discovered later that some machinations were engaged in to shift signatures. We have forged documents, unfortunately, pretty regularly, and this is just one form that these things take.
Okay,
So-
well, that actually answers my question. Thank you.
You're welcome.
Sorry, Olga, this is Shamanda. I have
Yes,
one
Shamanda.
other question.
Sure.
And this is actually about an old rule, but it sort of is jumping off the page at me. There is a section that talks about when there are 25 cases or more, and that the representative or the legal firm is expected to send an additional party.
Yeah.
I'd just like to ensure, for the petitioner, it is a little bit different for the enforcement agencies. And that's really because we never know how many people will show up versus how many people will not. So I just want to ensure that this rule is really more geared towards the respondent who has the ability and who knows how many cases they're going to handle, opposed to us where we have 800 or 900 cases scheduled. We certainly don't have an attorney, you know, to divide that by 25 and have an attorney for each one.
Oh, this is entirely, Shawanda, this is entirely for the reps and the attorneys.
Okay.
Yeah.
Thank you so much. Much
No.
appreciated.
Sorry, Olga, can we go back to this point about the original versus electronic signature?
Sure.
If there is a method of electronic signatures, we will accept. I think it's important to specify that, because irrespective of what we're saying right now, it seems highly likely that the vast majority of the signatures are going to be via PDF, because that's frankly just how the world works. And I just don't think it's realistic to expect that most people are going to get an original signature. So if there is a method of acceptable electronic means, I think we should make that clear about how that would work, whether it's a DocuSign or some other more formalized electronic signature that would be acceptable.
That's something that I don't think would be too much of a lift with the law department. I don't think we would specify a DocuSign, because that's just.
I'm not saying specifically DocuSign, but whatever it is that would be an acceptable form of electronic signature. Because I just don't think it's practical to these people. They're coming in the morning. They're not going to go in person to sign this document when they find a respondent, or especially if they're of a smaller case. Some of these fines are $100. You're not going to take your morning to go to someone's office in the last minute to sign something. So I just want.
I think that I'm sorry, this is Amy Slifka, and I think maybe there's some confusion. I think the intent was to have a signature on the NOA that wasn't electronic when the party appears in person. So
I think it only has to be presented when it's in person, but I think what Olga was saying is it still has to exist and be maintained by the rep, even when they're appearing electronically. So I agree. I definitely agree with Matt that if there is an acceptable form of electronic signature that, you know, and however it can be characterized in the rule, that it should be, because as it reads right now, that doesn't really seem to accommodate it.
However, one thing is that electronic signatures are considered original signatures. So we would have to see if even we need that additional word. We can think about it a little. We can think about it a little more and discuss it with the law department, perhaps. But my understanding from litigation that I've engaged in is that electronic signatures are considered original signatures for all intents and purposes. So let's see if there's an extra word or something that we have to put, or if the law department says that this language is sufficient to cover us legally, we'll go from there. Does that work for you guys?
Sure.
Yes, and presumably it could be explained in greater detail on the website, even if the rule is not specific.
Yeah, I think that's something, because I know from litigation that we've done that it's no longer a legitimate argument to say that an electronic signature is not an original signature. It is now considered, for all intents and purposes, an original signature. But I like the website idea. With that understanding that we'll just reconsult with the law department and definitely have something on the website, is this something that the board would be willing to accept, these rules?
Olga, I'm
Yeah.
sorry to interrupt, guys. This is Shamanda Graham. Just one suggestion that might make this very, very easy and make everyone comfortable. I think maybe just a one line or a few words that says that the signature has to be consistent or compliant or pursuant to the Electronic Signature and Records Act would probably do the trick, because that's the act that basically says the electronic signature has to be deemed has to be accepted as an original signature. So long as the signature is consistent with Ezra, then it would really be okay. And that's not that many words, and it makes it very clear. And it actually embodies a full body of rules about electronic signatures, just simply by saying consistent with Ezra. So that might make sense. But,
I think that's a very good idea, but that's something that I would have to consult with both clerks and hearings about in terms of what actually happens there. But I think it's a very good idea. I wouldn't want to create a situation where we're letting in a lot of things that we don't have the resources to review. Right. So I think, what do you think, Amy and Maria?
Yes, I'm okay. I mean, for my part, I'm okay with working some way to allow for some type of electronic signature. I kind of agree. This is a new world, and other agencies, other parts are accepting it. So I'm fine with it. Maria, I don't know where you stand on that. You're on mute, Maria.
I apologize. I missed the last part of that. I'm
Whether,
sorry.
whether you would be willing to allow for some sort of electronic signature.
If it can be verifiable, and I actually agree with whoever made the suggestion that we don't have to put it in the rules. We can just define it on our website. And the electronic would have to be something that's verifiable, honestly, because I deal with this at least once a day of people who claim that there is unauthorized representation. And sometimes they claim unauthorized representation after they got the decision and they lost. So, I do want to make sure that as long as it's verifiable, we'll be okay with that. But I don't really think, I think your point about it being an original signature includes those verifiable PDFs.
I have a suggestion. I also have, maybe we can talk about that in the statement of basis and purpose.
Oh, that's good. Yeah.
Keep that, keep
Right.
the word original, because original is a big basket, so that we don't have to be messing around with the rule at this stage. And then in the statement of basis and purpose and in the website, we say Ezra electronic signatures are deemed original, etc. Would that work? When we can make it very plain that a signature permissible under Ezra shall be deemed an original signature for purposes of rules section blah blah blah. Would that work?
Love it.
I think that would work.
I
Well,
love
that,
it.
that works for adjudications.
It works for us too.
Okay, so we'll do that. We'll do that. I'll change the statement of basis and purpose. And then, but with that change and the website, are we good with this rule?
Yes.
Thank you. So Joy, can you please get a sense of the vote, please, on this?
Yes, we do need a motion, please.
Oh, yes, I'm sorry. Yes, so can anyone make a motion?
Motion.
Thank
Shimon
you.
Graham, my motion.
And Madeline second?
Thank you so much. At this time, I'd like to ask if there are any objections to approving the representation and appearances rules as amended with the amended statement of basis and purpose. Okay, thank you so much. The motion passes.
Thank you so much. Okay, and we have the next up is another proposed rule, a more thoroughgoing amendment of oaths, representative misconduct provision. And I just want to send this rule basically is the result of an analysis that we did of litigation of cases that we've had on this area, in this area, in federal court, in state court, et cetera. And so we put everything together to craft this particular rule so that we would be consistent with the requirements of the law with respect to due process, et cetera, et cetera. I'm happy to answer any questions anyone might have. Any questions? No questions, it seems. So can I have a motion, please, to approve? Oh, thank you. Motion by Joe, second by Madeline. Joy?
You said the motion was made by Joseph Gregory?
Yes, and seconded by Madeline.
Okay, at this time, I'm going to ask whether there are any objections to the approval of the proposed rule governing the conduct of registered representatives and parties before Oath Hearings Division. Are there any objections? Okay, at this point, that rule is approved. The proposed rule is approved.
Thank you very much, everybody. Next up on our agenda is Russ Percunis from DEP, who's going to present the cease and desist orders. Russ?
All right, thank you very much. Good morning, everyone. My name is Russell Percunis, and I am in the Bureau of Legal Affairs at the Department of Environmental Protection. For this month's meeting, DEP is requesting that the board approve a cease and desist order in the matter of Zhang Corporate Group Incorporated, which does business as the restaurant Q Ramen and is located at 210 East 14th Street in Manhattan. This business was initially cited by DEP for a violation of Section 24-227 of the Administrative Code for excessive noise from its kitchen exhaust on March 23rd of last year. The respondent stipulated to that violation on May 12th of last year, and that stipulation included an order to come into compliance forthwith. Another summons was then issued on June 17th of last year, and the respondent was found in violation after a hearing that was held on September 13th of last year. The judge's order again included an order to come into compliance immediately. A third summons was then issued on October 21st of last year, and after going into default, the respondent has now rescheduled that summons for May 2nd. And most recently, on February 22nd of this year, the respondent was again observed to be in violation for excessive noise from the kitchen exhaust, and the hearing date on that summons is April 25th. Because of the repeated summonses that have been issued for excessive noise from the kitchen exhaust at this location, and the continuing failure over a period of almost a year of the respondent to come into compliance with the noise code, the department is requesting that the board issue an order to cease and desist.
Are there any questions? Does anyone have a motion to approve? Elizabeth, and seconded by Jared.
And seconded by, please.
Jared Whittington.
Thank you. Would you like, I can go ahead, and since this motion is on the floor, we have a motion request to for a cease and desist order against Zhang Corporate Group Incorporated. Are there any objections to this motion? The motion passes.
Thank you very much, everyone.
All right, thank you, everyone.
Thank you. Do I have a motion to go into executive session? Matt, seconded by Joe.
Hey, are there any objections to us going into executive session this time? Okay.
So, is everybody back in who's supposed to be in public?
Yes.
Okay. So thank you very much, everyone, for your participation in the executive session. I would like to, does anyone have any additional questions with respect to the full board appeal? Or are we ready to just make a motion to take a vote on that? I don't see that anyone has any questions on that, and I'd like a motion, please, so that we can make a determination with respect to the full board appeal.
Motion.
Tom Schwetner, motion and seconded by Madeline.
At this time, I'm going to do a roll call. We're going to vote. The motion, I believe, is whether to find the general contractor in violation or to dismiss against the contractor. Olga Stats,
Dismiss.
Shamanda Graham is sustaining because the case comes from her agency. Joseph Gregory.
In violation.
Thank you. Elizabeth Nauer,
In violation.
Madeline Legori,
In violation.
Jorge Martinez,
In violation.
Russell Pecunas,
In violation.
Matthew Snide,
Dismiss.
Thomas Schneppner,
Dismiss.
Matthew Smith,
In violation.
and Jared Whittington.
Dismiss.
So it is 6 in favor of violation, 4 in favor of dismissal, all short of the 7 required votes to make a determination.
Therefore, as required in the regs and in the law, the hearing's decision stands. And we will so inform the litigants by letter. Are there any additional questions or concerns about that? Thank you very much. So we're going to turn to the part of our meeting now where we select a date for the next board meeting. The suggested date is June 9. Does that work for everybody?
Yes.
I happen to be out of town that week, but if I'm the only one, then you can proceed and I'll have to miss the meeting.
Okay. Anybody else?
Give me one moment, guys. I'm checking my calendar.
Okay.
May also be out of the office that day.
Is that you, Madeline?
Yes.
Okay,
I'm good.
you're good. So we have, and everybody else is good? So that's potentially 2. So should we look for another date where everybody can be there if we're down 2 people? The other dates are June 2nd and June 16th. Is there one of those dates where everybody pretty much thinks they can be, they're going to be around?
I could not do June 16th.
You cannot do June 16th.
Cannot. I can do the other 2 dates, but not. the
Okay,
16th.
how about the 2nd? Is everybody good on?
Can't do June 2nd.
Okay, so let's have the next board meeting on June 2nd. Does that work for you? No, Matt?
I think Matt Smith said no. It's June 2nd.
So,
It's 2 out on June 2nd.
so wait a minute. How many people would be out on June 2nd? Matt,
And
who else?
Jared,
No, Jared can do
No,
June 2nd.
I'm available June 2nd.
He's not available June 16th, so,
okay.
Right.
so at this point, since we're trying not to have more than one person who can't make it, does that work for you, Matt? Would that be okay if we proceed on June 2nd? Because you would be the only one out. Is that okay? You're good? So if you could send someone else in for you, Matt, that would be great. Thank you. So let's say June 2nd. Do I have a motion? Matt moves. Do I have a second? Elizabeth?
And I will call any objections to our next meeting on June 2nd. There being none, our next meeting date is June 2nd, 2022.
Thank you so much, everybody. It's always so nice to see everyone. Are we done or are there any questions?
I
Thanks
just
a
wanted
lot.
to extend a welcome to the new commissioner, the incoming commissioner.
Yes.
Thank you, Elizabeth.
Same here, welcome.
Welcome. Welcome aboard.
Thanks, everyone. I appreciate it.
Pun intended.
And I learned a lot from today's meeting, so thank you.
Thank you very much. Bye, everybody. Be well.
Bye-bye.
Bye,
Yeah,
guys.
bye.
Bye.
In town.
Thank you.